My name is Jill Headrick, and this speech is titled Defamation and Invasion of Privacy. There is a sacred realm of privacy for every man and woman, where he makes his choices and decisions. A realm of his own essential rights and liberties that the law, generally speaking, must not intrude. Said by Geoffrey Fisher, Archbishop of Canterbury. As American citizens, the right to privacy has been stretched exceedingly thin because we are increasingly becoming a more global society. As advancements in technology are being made each year, the accessibility and availability of information has increased, making it almost effortless to obtain disclosed information. According to Robert O'Hare Jr., author of No Place to Hide, technology is being deployed at every law level of enforcement and intelligence. It's vastly more powerful, varied, and sophisticated than ever contemplated those many years ago. As a consequence, the president's wish may come true, and the terrorist may have no place to hide. But then, there's a chance that neither may we. In a country that prides itself on individual freedom, this poses a huge concern for many American citizens. According to David Holtzman, author of Privacy Lost, privacy has taken on another connotation. It has come to mean the loss of control of personal information, generally due to technology. With advancements in technology being made, this makes invasion of privacy that much more of a risk. For many Americans, personal freedom is closely intertwined with privacy. According to Lawrence Gostin, professor of global health law at Georgetown University School of Law, above all values, Americans prize freedom, the right of individuals to control all aspects of their lives, including personal and the economic. A core American value, privacy, is closely related to freedom and clearly illustrates the tensions between the individual good and the collective good. The Constitution reserves to the people the right, and the laws were made to protect people. According to David Lanois, author of Privacy in America, it was not until the Privacy Act of 1974 that for the first time gave statutory recognition for a right of privacy to American citizens. It set up certain constraints against federal governments. The Privacy Act of 1974 protected federal government records pertaining to individuals. The Privacy Act prohibited unauthorized disclosures of the records it protected. It also allowed individuals to see if any of the records were disclosed at any given time. Federal government set the groundwork for privacy laws, but it is actually up to the states to adapt and modify the laws to meet the needs of the communities within their state. In Illinois, privacy laws were created to protect Illinois citizens under the Illinois Constitution. Under the Constitution of the State of Illinois in the Bill of Rights, under Section 6, titled Searches, Seizures, Privacy, and Interceptions, the law states that people shall have the right to be secure in their persons, houses, papers, and other possessions against unreasonable searches, seizures, invasions of privacy, or interceptions by eavesdropping devices or other means. This law was created to protect the individual's privacy, yet the law itself is very vague and is not very specific. The law does not specifically protect citizens from invasion of privacy on the internet, and therefore the law needs to be modified in order to protect all citizens from all types of invasion of privacy. Advancements in technology make it harder to place restrictions, but privacy laws need to be regulated to meet the needs of modern society. The concern of invasion of privacy is very closely related and can be connected to the term defamation. According to Thomas Tedford and Dale Herbeck, author of the textbook Freedom of Expression in the United States, each person has the right to protect his or her personal reputation against slanderous remarks that destroy the person's standing in the community. The common law proposes that speech can be called defamatory if it tends to lower a person's reputation before others, cause that person to be shunned, or expose that person to hatred, contempt, or ridicule. In reference to the law, a person has the right to protect his or her privacy and has the right to protection against defamation. For a person to be defamed, their personal information must have done significant damage to their personal reputation. When an individual's private life is exposed to the public eye, and it results in the individual's reputation being damaged, this can be referred to as defamation. There is a significant connection between defamation and the invasion of privacy. In Illinois, laws regarding defamation were created and are closely related to the federal laws regarding defamation, but have some select differences. Some say that Illinois laws are actually more lenient regarding defamation than federal laws, but more recently, Illinois has modified this law and adopted a law that is going to provide more protection for citizens against defamation and privacy invasions. As American citizens, we have a right to privacy and the protection against defamation. However, with an increase in technology, it becomes harder to put restrictions on defamation and invasions of privacy online. However, this action needs to be taken to protect individuals.